Hi, I'm Jack from GatelyAcademy, and in this lesson we're going to talk about the Massachusetts Commission Against Discrimination and the ADA, the Americans with Disability Act. So let's start off with MCAD, the Massachusetts Commission Against Discrimination. You might remember that we spoke about them in one of our earlier videos about the Board of Registration. That is because should you, as a licensee, be found guilty of a proved violation of the Massachusetts Fair Housing Law, then the Board of Registration that holds your license is going to revoke or suspend, I should actually say, your license for 60 days. So a proved violation of the Massachusetts Fair Housing Law is going to be an automatic suspension of 60 days. If you get a second violation within 2 years, then it's an automatic 90-day suspension. Then it's automatic 90 days suspended. That is if a complaint, which is filed with the Massachusetts Commission Against Discrimination, goes all the way through the hearing process, in that the commission then makes a final adjudicatory decision of a proved violation. Now, there are other instances where that never happens, and instead a consent decree, kind of think about it like a plea bargain, is arranged well before the official hearing. So I want to show you a recent consent decree announcement from MCAD that just came out in February of 2019. Okay, so here we are here on the mass.gov website, and there's a press release from the Massachusetts Commission Against Discrimination, and it says Boston Rental Housing Company agrees to address allegations of discriminatory practices. This is from February 1st of 2019. So this is a very interesting situation where the Massachusetts Commission Against Discrimination and Suffolk University Law School work together on this particular project. So here we are, MCAD, in coordination with Suffolk University, has entered into a consent decree with Boston's Prestige Rental Solutions. The consent decree addresses allegations. You see, those are allegations. They're not actually proved allegations. They're just allegations that Prestige Rental Solutions discriminated against families with young children seeking rentals. So this case revolves around families with children, especially children under 6, looking for rental property and being denied that rental property, highly likely because it had lead paint. So there is a significant number of folks out there that are doing the wrong thing, and they're denying showings because the family includes, or the applicant includes, a child under 6. That is patently illegal. You cannot do that. That is discrimination based upon the presence of children in the family, or what a lot of folks otherwise call family status. So here in this press release here, we understand that the real estate offices in Alston and Jamaica Plain of Prestige Rental Solutions testers reported that they were refused information about advertised rentals by one of the agency's licensed agents and steered them away from apartments that were not de-leaded, according to Suffolk University and MCAD, based upon the results of the testing. And when they say testing, they mean that and highly likely they used Suffolk University Law School students to inquire about these apartments. Beyond these, based on the tests, a formal complaint investigation was launched, and as a result, Commissioner Hubbard determined that there was sufficient evidence. That's not proof, but it's sufficient evidence to support the allegations under state and federal anti-discrimination laws. The rental company consented to cease any discrimination practices, make a charitable donation of $6,000 to Suffolk University's testing program, and send their real estate agents to fair housing training. So as you can see, that sometimes if you have an issue before MCAD, it might not actually get to the point of proved allegations, but there might be a situation where it makes sense to enter into a decree agreement, as we've seen here. Now let's talk about the American with Disabilities Act. First off, modifications. And these fall under actually two categories. There's landlord modifications, and then there's tenant modifications. So landlord modifications would most certainly be covered in areas of like the common areas of the building and surrounding of the building. So these are things that might fall upon the landlord if they are deemed to be reasonable. If you have crutches, for instance, and you have a third floor apartment, it would not be reasonable to have the landlord install an elevator. That would be obviously cost prohibitive. But there are other things that might make sense. For instance, locating your parking spot, if parking's provided at all, but let's just say it is, locating your parking spot closer to the building, that would be considered reasonable. Tenant modifications. The landlord must allow or grant permission for the tenant to make modifications to their own unit. Now, those are at the tenant cost, but the landlord cannot deny permission, for instance, to widen a bathroom doorway, so allowing a wheelchair to get in. Actually, that sounds like a really good test question, doesn't it? Service animals. That's an interesting one. We're going to take that one up last on this video. But a quick note, landlords cannot require an additional security deposit. If you have any type of disability of any nature, you cannot be charged an additional security deposit. That is absolutely a no-no. Same thing goes with service animals. If it's an official designated service animal, which we're going to talk about in a minute, you cannot be charged an additional security deposit for your service animal. All right, so let's talk about service animals. So service animals, according to the ADA, is limited to dogs that perform a particular task on someone's behalf. Although it also includes a dog that helps with PTSD. So it's not only for dogs that provide certain assistance with sensory deprivation, but also for PTSD. If you're a property owner or a rental agent, you are not allowed to ask for documentation to prove that the dog is a service animal. That's very important. Service animals are not to be considered pets, so they do not fall under the no pet category or anything like that. You can't charge extra pet rent because they're not pets. They're service animals. They're service animals. They're not required to wear a vest or anything like that. Well, that is common, but it's not required. Now, there's this other category called assistance animals. Sometimes you might refer to them as comfort animals or emotional support animals. And their sole purpose is for the comfort and emotional support of the individual. So that's a little bit different of a mission than the service animal. Now, for assistance animals, as a rental agent and or a landlord, you are allowed to request documents proving that they are, in fact, an assistance animal. Here's where I'm going to strongly recommend that you tread lightly, and where I do believe that this particular video over time will need to be updated. So I'm going to include down the bottom here a link to the mass.gov website that describes these two categories. And I would imagine that over time, this will be, as I said, evolving. Hey, I'm Jack from GatelyAcademy. Thanks for watching.